Hold on.
because
Okay, go
all
now.
right.
So this is Stefan Kinsella. I'm going to do this as podcast KOL467, and I'm talking to Juani. From which country are you from?
Argentina.
From Argentina, about intellectual property. You had written a draft article on IP,
Hmm.
and it's about 25 pages. And I commented on it briefly, but I got Grok to look at it, gave you some other articles to look at, and then we can talk about it. So go ahead. Tell me what your view is and what you want to discuss.
So, I've got a rather standard libertarian view on intellectual property, and it was shaped in great part by your works, but much of it actually comes from a lot of personal thinking and a more of a consequentialist view on the issues caused by intellectual property. So my criticism of intellectual property is not necessarily so much on the philosophical side of it, but on I guess you could say it is a bit more utilitarian in nature.
Well, hold on. Before we go there, let me ask you a question. So, are you a student or a scholar, or what's your?
Um, I'm actually just a programmer.
Okay.
Already, I already got two technical degrees from a university, but I've never done anything in this sense. So I'm more of a like a you could say an aficionado in this. I'm not
That's fine.
necessarily a
And are
scholar or anything
you?
like that.
Would you say you're a libertarian or anarchist or
I consider myself a voluntarist, just do
okay?
not necessarily say anarcho-capitalist, mostly because I
Yeah.
perhaps have a few teleological differences
Yeah.
with the average anarcho-capitalist. And
Hmm.
because basically that word, when you say to someone, yeah, I am an anarcho-capitalist, they look at you like you just said you're a
Yeah.
Nazi.
No, I just want to see where you're coming from. Are you Austrian sympathetic, Misesian,
Austrian sympathetic,
Rothbardian?
yeah. Can't say that much knowledgeable on economics. That's not necessarily my strong point yet. But yeah, I'm Austrian, Rothbardian. Um, you could say that I'm very much standard in that sense. Probably have a bit more of left libertarian leanings in some stuff.
That's fine. Okay, hold on just a
But
second. Let me. I'm gonna pause this. I need to grab a new battery for my fan. Give me just a
sure thing.
second. Okay, back. And are you a fan of Malay, or what's your situation on your views on Malay?
Yeah, yeah, pretty much so. Or at least on most of his stuff, like, I absolutely love his reforms. In terms of intellectual property, he hasn't done so much yet, but he has, for instance, we used to have our society for artists and musicians and composers, the one that writes everything, the one that manages everything related to copyright over music and phonographic rights. He had removed a few regulations that, for instance, made you, if you, let's say you own a business and you played music on Spotify, you were supposed to pay royalties to the artists in order to play that music in a public space. And that even, that could even apply if you played your music at your home, loud enough for people outside to hear.
Hmm.
So naturally, he removed that. Was one of the few IP related reforms he has done so far, from what I know. And well, unsurprisingly, a lot of people, especially most mainstream musicians, had a they had a complete meltdown over it. So far, nothing so bad has happened. So in that sense, yeah, I absolutely
Okay,
support the guy.
I wasn't sure what his views on that were. I think someone told me he had read one of my books, but who knows?
I'm pretty sure
Uh,
he must have read some of your books since he is like, from what I know of him, he is absolutely reading all day. So I'm pretty sure he knows you well. Um, but the thing is that his reforms are much more pragmatic.
Yeah.
He hasn't touched much on IP because I guess he has a more random view of how to deal
Right.
with government.
Right. Well, maybe if you can find an article that explains what he did on the copyright issue and what controversy it had, I could take a look at that. But anyway, let's go ahead. Tell me what anything you want to discuss or what questions you have.
All right, so I had written this essay, and it's pretty much an argumentative essay that I wrote when I began thinking a lot over my own criticisms of intellectual property, and it is something that I hadn't necessarily seen a lot of people discuss directly because a lot of works on intellectual property are more on the philosophical intricacies and the problems with it, not so much as as what I perceive to be the real world problems. Not to say that you haven't written about it, you have written extensively about, patent trolls and the problems with big pharma and patents and that stuff. But I was thinking a lot of this and I wanted to organize my thoughts. So I wrote this essay, which is titled Ideas Are Free, a case against intellectual property. And one of the things that I did, which is something that I would like to discuss with you about principally, is I began thinking a lot about intellectual property as it relates to artificial intelligence. You see, artificial intelligence is still very much new in the sense of how it has entered the mainstream. It has existed for a long time, sure, but right now we got generative AI, and you can simply go ahead, open up ChatGPT or Grok or any other model. You can input a prompt, and you suddenly are gonna have probably you can get an entire essay on any topic, or an entire news story, or you can even have a whole poem, a whole lyrics book written by an AI, a whole song, a movie script, whatever you want, you can have it generated by artificial intelligence right now. And I realized, hey, how does IP, specifically copyright, but also patent rights, come into play here? Because recently, this is something that I mentioned in my article or essay, more like. There have been a series of lawsuits regarding IP over artificial intelligence models. You got Auto Skills versus OpenAI, Silverman versus OpenAI and Meta. And these people, mostly others, filed lawsuits to these companies because they said, hey, your model is capable of generating stuff that's very similar to what we wrote and own copyright over. And so this brought forward the question of like, how do you determine what, how do you determine that the AI generated something that's similar to what you own copyright over to your works if you cannot necessarily prove that they were trained on your works illegally as in without a proper license? And isn't this just, a case of parallel thinking carried out by a computer? And who do you blame? Do you blame the user who made the prompt? Do you blame the people who run the AI model and train the AI on that data? And even then, if they didn't train the AI on your works, if you engineer a prompt long enough with enough specifications and stuff, you're gonna eventually have the AI generate something that is legally questionable. And so that
Well,
brought.
let me interrupt with a couple things here that you might not be familiar with. There's two
Mhm,
issues you're kind of blurring together. So one is the issue of authorship.
mhm.
So let's forget about the copying, but let's just suppose you own a computer and you program it um, to just generate things, and it generates a pattern like a picture. Then the
Yeah.
question is there a copyright in that, and who owns it? Obviously, the machine can't own it because machines can't own things. But it might not be owned by anyone. There may be no copyright on it. There have been some disputes about this example where some photographer or some person gave his camera to a monkey called a macaque, and he took some pictures which became famous on the internet. And the courts ended up holding that there's no copyright because there's no author. Now, on the other hand, you know, if you throw your camera up in the air and it takes a picture and you catch it, you could say you took that picture. If you set up a stationary camera like on your building and it just takes a movies of the parking lot for security, is there a copyright in that? Is there anything artistic or original about that? I don't even know the answer to that, but there are questions about who the author is and whether there's a copyright in something. So that's a separate question. So the question is if AI generates an artwork, is there a copyright in it or not? And if it's totally original, I think the argument is either that the person who programmed it is the author. Like if you give it enough prompts to tell it what to do, you could argue that you have a copyright in it, similar to the way photographers have copyright in photographs, even though they're in a way factual representations of the world. And because the law decided long ago that there's a minimal enough original contribution on the part of the photographer in telling the camera what to do, the shutter size, the lighting, that's enough to give it originality. But if there's no contribution at all, like you just set the camera up and it records for days a parking lot, I don't know if there's copyright in that, and I don't know how much the author. Now, of course, there's no objective answer to these things, and this shows that there's something wrong with copyright law.
Yeah,
Now, the
that
other
is
question is,
something I
so the other
mentioned.
question is though, the other question is this: you have to understand that copyright covers a group of rights, one of which is copying, which includes what's called literal copying or exact copying, but it also includes sufficiently similar copying. So, like if you take someone's book and you change the wording a little bit, it's still a copy because it's close enough, it's substantially similar. Or if it's a literal copy, it's a literal copy. But there's another type of copyright which is called the derivative work, and that is when you make something that's not a copy, but it's based upon the original idea. So if you make a translation of a book, or if you make a movie based upon a novel, those are not copies, but they're still a violation of the copyright because the right to make a derivative work is also one of the rights. So the question would be, if you program an AI to generate a new work and it uses other people's copyrighted material, is that a derivative work that infringes on the rights of the holder? And then the other question, you mentioned this thing about inevitably the AI will generate something that would get into trouble. I don't think that's necessarily true. If you just have an AI randomly generate things, and it's not based upon training data, if it happens to be the same text as Atlas Shrugged or a novel, it would not be a copyright infringement because it wouldn't be a derivative work or a copy. It would just be the same idea, the same pattern by coincidence. In fact, there's one copyright researcher, Damian Reel, he did an experiment where he used a computer to program all the melodies of music, and he thinks that would be used as a defense in copyright infringement. He's kind of confused about the law, but it was that kind of little trick he tried to play. But I think the more interesting question is this: in real world applications, you have to train the AI, and to train it, it has to have a lot of data. And that means it has to have real world data, which is scanning all the books, all the websites, is scraping all this data. The question is that scraping, which requires temporary copying, is that itself copying that violates fair use or copyright law? So that's the question. And there's uncertainty about that. And there's lots of lawsuits that are coming, which are threatening to chill. In fact, I've tried, I'm sure you've tried, if you ask Grok or ChatGPT to give you some quotes from some novel, it's sort of paraphrases or it's limited in what it does. And I think that's because the programmers are intentionally hobbling AI to try to avoid copyright infringement, which is a shame. It means it's going to distort and impede how efficient and how good AI technology can be. So we already are seeing copyright have an effect on on how good AI can be. So there is definitely a tension or a
Yeah,
conflict between AI technology and between protecting copyright. You can't have both. But go ahead.
I wrote rather extensively about that. Like it's this part of the essay is called IP in the AI era, or
Yeah.
IP in the AI era, or the revelation of a contradiction. That's what I titled that part. And I wrote extensively about it. I explained to whoever is reading that essay that, hey, AI needs data to be trained. These data sets are often not picked, like not handpicked. They usually are like many terabytes of different stuff, books, images, videos, internet comments, tweets, that sort of stuff. And naturally, you're bound to have copyrighted stuff in that. Like a lot of AI models are trained on, for instance, tweets or Reddit comments or forums, blogs, all this stuff. And inevitably, you're going to have like a lot of Reddit comments which directly quote some copyrighted book. And you cannot really go ahead and check every single one of those millions and millions of comments, which would probably take a person thousands of hours just to make sure, hey, this might be copyrighted, so we cannot include this specific
No,
part of
no,
this data
it's
set.
impossible. It's impossible. It's
Yeah,
impossible.
it
You're
is
right. It's
impossible.
impossible.
But the problem is that for regulators, they generally don't care about these implications because they're gonna see that there is a copyright violation, and
Yep.
they're gonna go, hey, well, it's your fault. It doesn't matter if it was not sensible for you to go
No, they're
ahead
right.
and
No, they're right,
filter
and
all
they're right.
that.
It is your fault. It's your fault because the law makes it illegal for you to copy things. That's the
Yeah, well,
problem with copyright law.
yeah, that's the problem, and I do mention it. And yeah, well, you were saying that if the you were asking if the AI generates a new work, is it a derivative? Is it a copy? Well, I guess there is no real answer to that because AI, at the end of the day, it's gonna generate stuff based on what it is trained on. If you don't train an AI on anything, then it cannot generate anything. At best, it's gonna be like monkeys banging on a typewriter. And even then, I mean, imagine if monkeys banged on a typewriter for millions of years, you're gonna eventually have them copy all the works of Shakespeare, or
Yep.
because they are in the public domain, let's say
Well,
they're
no, they wouldn't
gonna,
be copying. No, they wouldn't be copying it.
well,
They would be
not copying, it would be
they'd be
completely random.
independently, yeah, independently stumbling across the same pattern. That's true.
Yeah, well, but AI technically, well, not technically, but in a practical sense, it sort of does that because AI works
Right.
on on a probabilistic model, so it just
Well, and it
generates
works. Hold on,
stuff.
hold on. It works on training data too, so it's not doing it randomly. That's not
Mhm.
how it works. So in the real
Yeah,
world, it is based
it's an
upon.
oversimplification, but you're gonna eventually probably have an AI generate something by sheer chance that might be
Yeah, but that's not the
copyrighted.
problem. That's not the problem. The problem is that it's actually copying. Like if it goes on the internet and scrapes the
Yeah, if it
internet
goes,
content, or that's a copying. It's doing a copying, and then it uses that data to train its neural net programs. And it's the copying right there that's a problem. And then it's what it produces that's a problem. I mean, look, if I go to Google Translate right now and I type in,
mhm.
I feed it in uh, a Harry Potter novel and I say, translate this into Spanish, it produces a work which is a derivative work of the original. And if I publish that, I'm violating copyright law. It's got
Yeah, yeah,
nothing to do with how I did it. It's the fact
yeah.
that I am,
But that's also
yeah.
something that I do touch on, and I say
Okay.
I I I'm gonna cite the example I made. So, um, quoting from my essay, imagine you ask a large language model to generate a particular story about a young guy with glasses who goes to a school for magicians and then
Yeah.
finds himself trapped in a battle royale deathmatch with other students. And at some point, one of the characters also happens to explain to the protagonist the intricacies of wealth and income inequality in the United States and Europe since the 18th century. Then you share that story publicly. The AI, well, not the AI, but the content of the AI might be infringing on the copyright of multiple different authors by creating that story. So by sharing that story online, you might be trespassing on the copyright of all these people, right?
Yeah.
Now,
Infringing
yeah,
copyright. That's correct.
you share it, so you could say, well, this is your problem because you generated it, right? But if you go to court, I mean, you're the legal expert here. I'm mostly talking from what I understand about this. If you go to court, then you're probably gonna get yourself in legal trouble because you were the one to share that.
Yep.
But then I think like, okay, you shared it. Sure, you may not have any incidents if you didn't know that it was infringing copyright, but that's still your problem. It's not
Nope. Nope.
your
Nope. Nope.
fault
That's
that,
no. Ignorance is no defense. It's
yeah, right. Ignorance
copyright
is no
is a
defense,
strict liability crime.
which is also one of the problems that I have because it basically criminalizes parallel thought.
No, it
And
doesn't.
it's,
No, that's a confusion. It doesn't. It doesn't. Because copying. So you're getting confused with patent law. You're
yeah,
right
well,
about patent law. No, copyright.
yeah,
You have to have. So let me explain something. In the way the law works, in order to prove copyright infringement, you have to prove that you copied something, which requires you to prove that the copier had access to the original. Because if he didn't have access, then maybe he did come up with it on his own. It's just that it's extremely unlikely. And if you can find an exact duplicate copy of a novel, it's so impossible. You had to have access. And the same thing is true with AI. If AI generates a story which is very similar to another work, and you know that the AI was trained upon billions of pieces of data, which included that work, then you can prove that it probably had access, and that's the reason the new story is too similar. So it doesn't prohibit parallel or original similar ideas. What it does is it prohibits you from creating a derivative work based upon the original idea if you had access to it. But go ahead.
well, but then my question to that is, I mean, first of all, I was thinking more of I understand parallel thinking in terms of patents. I did also mention that. I was perhaps thinking of parallel thinking more in the sense of generated a work that is very similar to one that already exists, because then that is in many ways sometimes considered plagiarism, and it can lead to some legal troubles. But beyond that, you said that you need to have access to the work, right? So in that example, let's say that I asked Grok to generate that story, but I did not necessarily have access to those books that
No,
I'm referencing.
but
But
Grok
Grok,
had access to it.
yeah, but Grok had access. But how do you know that Grok had access? Because then if J.K. Rowling and other authors like Piketty, or I'm not really sure how his surname is pronounced, he sends me to court over that story, then they're gonna have to ask XAI to show the data sets they were training their AI on.
Correct. Well,
And they're
let me
gonna
say,
have to find those
hold on.
works there.
So let me explain something. Up until today, the way the law worked is it's not dealing with massive data sets and all this. So the way the law works for copyright is it has this test, and the test is if the new work is very similar to the old work, and if you can show access, then the court can conclude that there was copying.
Hmm.
But that test might change under AI because you might not be able to easily. In other words, you might the law might change where they presume access if the new work is too similar to an old work, and if the AI had access to the entire internet or something, the burden of proof might switch from the copyright holder to the defendant. The defendant to prove that they did not access data. So I could see the law changing to permit copyright to still work in a world where AI is doing a lot of the infringing. That could change. That's my guess.
Yeah, but then you got the lawsuits I mentioned, and well, this is perhaps something you may be better fitted to answer. Um, so you got these authors saying, "Hey, OpenAI infringed on my copyright because they trained their data model on my works." Now,
Yeah.
for that to come up, I mean, for that to really matter, you're gonna have to have the AI generating stuff that is similar to your works going public, and so then you're gonna notice that, because then I ask this question, like, you gotta train the AI, sure, and training the AI is in practical terms, as long as the AI is being trained and not necessarily sharing and generating your works or anything very similar to them. It's not different to a person reading your books in order to learn or in
It is
order to
different
get
though.
inspiration.
You could argue it's
Yeah,
qualitatively different. Yeah,
it's
that's what
called
they're going to argue.
sure it is, but what I'm trying to get to here is that, well, I mean, you could argue that somebody is infringing on your copyright by the way they're using your books, but they are doing so privately. I mean, if I will go ahead on my computer and begin training my own AI model.
Hold on. Let me mention something. There's private copying is still copying. If I have a
Mhm.
copy of the Harry Potter novel in my house and I put it on my Xerox machine, I mean my photocopier, and I make a copy, I'm infringing copyright right there
Yeah,
because I'm making a copy. Now no one can. It's hard to detect it, but that is technically it's not just the publication of a copying work. It's the copying which is the crime.
yeah, which is one of the things that I find completely crazy
There's
about it.
there's about 1,000 things that are crazy about
I mean, yeah,
all
there are a
IP law.
lot of
That's the
those,
thing.
but like the fact
Yeah,
that you can get into legal trouble over this, it's mind blowing. Like,
yeah, I
imagine you
know.
go back in time and you say to somebody like the first liberal thinkers, you go and tell them, "Hey, well, the other day I copied this one book and I
Hold
got
on a
the
second.
FBI
Hold on a
knocking
second.
on my door."
Hold on. I want to tell my wife to hold on a
Sure.
second. All right, I'm back. Go ahead.
Right. Okay. So as I was telling you, it's mind blowing. And when it comes to AI, well, I'm a software developer, a web developer, so I'm very much into this. It's extremely like, we need to understand that AI, generative AI specifically, is perhaps one of the most revolutionary, if not the most revolutionary invention in human history. Like, this
I agree.
stuff is gonna bring us to the next era of technology. It's like the modern day industrial revolution. And as it stands right now, we are very lucky because in terms of law and regulation and all this, AI is pretty much the Wild West. And unlike what many people think, the Wild West actually kind of worked, even if it had no formal law. Sure, it has its problems, and we can both see that. Like, you cannot right now, AI has gotten so realistic in generating videos that you can literally have people being like the whole likeness of people being copied, which can be extremely misleading, and that is a problem. But one of the things that I mentioned in my essay is like, there's likely somebody right now, as we speak, sitting in some office somewhere, maybe Washington, maybe Berlin, maybe London, somewhere in the world, going, "Hey, like, this AI problem, like, we got a problem here, not only in terms of copyright, but in terms of ethics." They're going to say, "How can we make sure that AI is not being used to spread misinformation or
Yeah.
promote violence or
Yeah.
scam people?" And then
Yeah.
I go like, okay, so these people, and there are many people that are not politicians, bureaucrats, but civilians, so to speak, like the average person who says, hey, we need to regulate AI right now because this is a problem.
Hmm.
And if we look at history, there were many industries that had like a boom, a golden age. They got regulated, and boom, they died like that, or not necessarily died, but they ended up being completely deaccelerated in terms of growth and progress. And the problem with AI then is, okay, so you regulate this, and you're pretty much given the state the capacity to use AI however they want, because the state never follows its own rules. That's that's like a given that a lot of people seem to not want to acknowledge, but the state doesn't follow its own rules. So you're gonna regulate AI, and then on ethical grounds, like, okay, so we're gonna regulate this because it's unethical to use it the way people use it, and the state is gonna
Well,
use it the way people use it.
yeah, let me interject for a second. Some of these concerns are not IP related, of course. It is true that state regulations distort and impede technology in a variety of ways. One of them is the regulations you're talking about, and copyright is another one. Now, up until recently, I've always said that patents are worse than copyright because patents
I agree.
impede innovation, and that is directly uh, harming the future of humanity because it slows down the accumulation of knowledge, which is how we become richer. Um, and copyright is a second because copyright lasts longer, but and copyright distorts culture, which is bad. But in today's world, one of the most important tools that we have to fight the state is communication on the internet and with encryption and cell phones. But copyright is being used to threaten freedom on the internet. So I always said that the biggest harm of copyright is that it can threaten freedom on the internet. But now with the rise of AI, I'm starting to think that there's a second and maybe even bigger harm to the extent that copyright distorts the development of AI. That might be the biggest single harm of copyright, even bigger than threatening internet
Yeah.
freedom, and it might even be worse than patent law. Although patents also affect the development of AI technology. But go ahead.
Yeah, it is what I also mentioned, that I mean, copyright is gonna have a massive, and I mean a massive, hindrance on the development of AI. Because the moment that authors and musicians and filmmakers and every other copyright holder out there realizes that AI models are being trained on their stuff, and that AI eventually is generating stuff based on their works, even if not directly, they're gonna say, "Hey, this is undermining my copyright. Um, well, my this is undermining my copyright," and they're gonna go ahead, and you're gonna have these huge lawsuits, and that's gonna be. I don't want to say it's gonna be the death of AI, because I'm pretty sure, I want to believe too, that the law systems are gonna see the training of AI using this data as fair use, or at least I
Well,
want to
hold
believe
on.
so.
It's possible. I mean, you may not be aware, but there are some countries, like I think in the UK, there has been
And
a bill
Japan,
proposed. Maybe they've been a bill proposed to relax the fair use rules.
yeah,
But of course, all the artists are fighting that, and I don't see that happening in the US anytime soon. And even if you do it, it will only be limited, and and what's going to happen is you're going to have these big AI companies like Chat GPT and Grok. They're going to go to the big providers of information like newspapers and publishing industry, and they're going to make a deal, and it's going to increase the cost, but it's also going to make the AI worse because now the AI can only use sort of limited sets of data instead of everything. It should be able to use everything. The mere fact that it can't use everything or it has to pay a fee is going to dissuade small startup companies from doing AI. Only the big ones will be able to do it. So it will tend to cartelize or cause a monopolized set of AI industries, the ones that can afford to pay the license fees. And the data will be worse because it won't be the full set of data it needs to do training. So that's another problem I see with the movement, even if fair use rules or fair dealing rules in other countries are relaxed. But let's hope so. But the point is, you cannot have copyright and AI. You just can't have both.
Yeah,
There, there's
I
there's
mean,
a conflict.
I think that IP is actually like it runs into a problem, not only copyright, but a patents too, and I'm probably gonna get into that in a bit. Um, it runs into a problem with AI because what is, I mean, so as to like to simplify, IP was like an invention in the modern sense that tried to exalt the creativity of people, saying, hey, well, you made the mental effort to come up with this particular idea, so you should have rights to monopolize it.
Yeah.
What happens when the AI is the one generating this stuff? And how do you prove that
Well,
that a current new idea, something like if I write a book or if I come up with an idea, how do I prove that it is not made by AI or at least not assisted by AI? And how
Well,
do I then,
like I said, but that's a different issue, and that the law is going to have to adapt there too, just like it did with the
yeah,
monkey copyright case, and you're going, and just like the law had to come up with rules to decide whether or not photographers get a copyright in photographs. I think obviously what's going to happen is if you're a researcher and you use AI as part of your tools, like a computer, to come up with a patentable invention, and you file a patent on it, then you will get a patent on it, and then someone will challenge it by saying no one should have a patent because you didn't invent it, Grok invented it. But then the law will sort that out one way or the other. But it will result in extra costs and uncertainty, and it will result in some IP anyway. So that's what's going to
yeah,
happen.
but then the problem is how do you objectively create laws that can deal with this? Because it's gonna be different in each case. You
You
cannot
can't, you cannot
really
because
have
IP law is
an objective way to say,
IP
hey,
law.
well,
Look, IP
I'm gonna regulate AI based on these rules of play. Okay, you're gonna
it can't be.
regulate it, and
Listen,
it's
listen.
not gonna.
You can't be objective because the law is not based upon anything objective. It's arbitrary and vague and unjust.
I mean,
And
yeah, that's the problem.
now the law can draw arbitrary rules, and that's what they're going to do, but they won't be just, and they will, to the extent that they favor IP rights, it will impede and harm technology. There's just no way around that. That's what's going to happen. That's the problem with IP. There's no way around it.
Yeah, and I mean, we're gonna, as I said, we are very much lucky yet so far that we haven't had AI be overregulated or regulated at all, really. And something that a lot of people are completely unaware of, apparently, is that AI doesn't even need any sort of regulation. There's no even, I don't think that there's even any sort of actual argument saying, hey, we need to regulate AI. It's not like the 1930s or 1940s aviation industry where you had people saying, hey, we need to regulate aviation because it is dangerous. No, it is not. I mean, this is not a problem with AI, and AI has a particular set of ethics that every single person engaging in developing AI has to adhere to because it is a professional standard. I mean, the industry is pretty much self-regulating. Even the issue of AI videos being used to replicate the likeness of people and use that for a scam or misinformation, AI companies are working hard to make sure that doesn't happen. I mean, AI companies are pretty much trying their best to keep themselves out of the embrace of bureaucracy, which is gonna absolutely fuck them down to the ground through regulation. But I'm afraid that this is not enough because you're eventually gonna have the state go ahead and regulate this either on the on based on some ethic grounds or whatever, or like to maybe perhaps from some regulators who might have some good intentions as if, but most likely the state is going to regulate that because it's first of all it's going to be useful to them because AI can be really be used by the state to for surveillance for economic calculation in those economies which are more like command based like China, and because AI can also be used to undermine the state. I mean,
Well,
What do you need?
by the way, to be clear, the state is already regulating AI because it
Yeah, it
has
is.
copyright. There are copyright rules already. I mean, copyright is already regulating AI technology. That's happening now.
Yeah, well, what I mean by regulation is like more direct regulation that directly addresses AI, and that's a problem. And I mean, if I'm gonna cite Albert Nock here at the end of his book, Our Enemy the State, he says, "What can we do against the state expanding?" Well, nothing. And I would say that he was a bit pessimistic on that. But if we look at it like, how can we actually go ahead and sit here and think of a way to say, hey, the state shouldn't be we need to keep the state from regulating AI because it's definitely going to use it for its own purposes while they won't play by their rules. Like they're going to impose rules on us, but they're going to use it however they want. And that's one of the main issues I got. And maybe moving now out of the AI thing, you were um, mentioning how copyright has a cultural impact. I mean, IP is censorship. I'm that's the best way I can put it. IP is censorship, and I want to bring up two particular cases that more or less prove this, and that's they are mostly related to Disney, and so
Mostly
Disney
related
a
to
lot
what?
of
To what? To what? Oh,
the Disney.
Disney. Disney. Yeah.
Yeah. Um, Disney is very much known for, first of all, copyrighting the first version of Mickey Mouse for like almost 90 something years, something like that. Like the original version, like the very first cartoon of Mickey Mouse, only entered the public domain like a few years ago, which is completely crazy because what they did with Mickey Mouse is basically copyright evergreening, because the current Mickey Mouse share is very different to the one that came up in the 1920s, but it is a character that was created in when 1928, Mickey Mouse, and it is still copyrighted mostly.
Yeah, well, the early films I think just entered the public domain. But that's just the early black and white ones.
Yeah, well, the black and white ones had like that first depiction of Mickey Mouse. It is in the public domain, but the rest is not. Even if Mickey Mouse is as a character,
Well,
well,
and not
almost a
only
hundred
that,
years
hold on,
old.
not only that, trademark law is another type of IP right. So there's still
Mhm.
trademarks on like the mouse ears, and so IP is not going away just because some early Mickey Mouse movies that are 100 years old now have entered the public domain. There's a long
Yeah,
tail
it's
for the
not.
copyright, and there's trademark, and there's trademark as well.
So, like, let's remember something here that Disney tried to get intellectual property rights over a musical scale. I, as a musician, cannot fathom this. Owning not a piece of music, not a composition, but an entire musical scale. This would imply that every single song, every single composition that is written on that scale would be, um, in technical terms, infringing on the intellectual property of Disney. Thank God this never managed to happen. But imagine if that would have happened. And what I was thinking of then, in
But
terms
hold
of
on,
how,
hold on, but it does happen in limited ways. So, for example, you can have a trademark on a very short tone, like
yeah,
the sound "ta-dum" on Netflix, probably trademarked, and there are songs like a recent lawsuit from a few years ago. There was this company that claimed the rights to the song "Happy Birthday,"
yeah,
and
Chapel, Warner Chapel, I think it was.
yeah, they went around for years extorting people to pay um, royalties, or movies or TV shows would just make up, or restaurants would come up with a new song so they wouldn't infringe copyright. And finally, the copyright was overturned, but it took
Because
years and
yeah,
millions of
but this
dollars.
because that song was actually written in the late 19th century. It should have been in the public domain.
Yeah, but the point is, copyright is vague and arbitrary, and you never know, and you can use it to bully people even if you shouldn't have a copyright.
Yeah, and
You're gonna get these things.
that's one of the main problems about it. And as I was telling you, that's not the only problem. The one of the problems that I noticed is that copyright is capable of cultural erasure, and it can be
Yes.
used by the state to collectivize individuals and smaller communities into like this greater sort of community that the state wants to create, where everybody is equal in terms of how they relate to the state. Everybody is supposed to be, I guess you could call it like this sort of erasing regional and personal and ethnic yeah, identity to create a national identity in a way that legitimizes the power of the state. Because, well, modern nation states are mostly supposed to be based on the concept that a people that lives in a territory and shares a common culture and common history is given the capacity to rule itself. And this is undermined when you've got, for instance, in the US, you've got all these indigenous American groups which claim their own um, lands as their own territory, like it does not belong to the US but to them. And you then also got a divide between, for instance, the people who live in Texas, who might not necessarily be very fond of the federal government, while some others who live, for instance, in New York might. So you end up having this problem where you can use copyright to erase their culture in a way that dilutes them into the mainstream, into the general idea the state wants to people to have of themselves. And two good examples I can provide of this relating to Disney are Pocahontas and Mulan, or Mulan. I'm not really sure how it is pronounced in English, but Pocahontas was a native woman. I think she was of what today is Mexico, and she was literally forced to convert to Christianity and to marry John Rolfe entirely for propagandistic purposes to legitimize colonial rule over
Yeah.
indigenous Americans groups. And what happened to her in the Disney history? She was literally made to be like this hero, I guess. It was turned into this romantic story which completely sanitized what it was done to her and her people by the colonial rule of that time. And the thing is, a lot of people don't realize Pocahontas actually existed. They think she is a Disney story. And the same with Mulan, who was, according to sources, she actually did exist. And well, she was like, she represented Confucian values and was like a more of a, in Chinese culture, she has more of a the traditional role of a woman. And the version by Disney basically downplayed these traditional Confucian values and repackaged her and her life as some culturally grounded legend about some hero, which
Yeah, yeah,
completely
yeah. And by the way,
panders to Western.
if you try to publish the true story of Pocahontas, you might get sued by Disney. And so
Yeah.
you might win, but it would be expensive to fight it. So it would dissuade people from telling the true story because they might want to show might want to show clips of the Disney movie in their documentary or whatever to show the difference. So, but all you're doing, I think, is pointing out all the obvious negative effects of IP law, which are pretty well known. I
Yeah,
mean,
they are obvious, but a lot of people don't realize this, and
I
that's a
know.
problem because if you go now, right now, you go on the street and begin asking people, "Hey, do you know what do you know about Pocahontas? What do you know about Mulan?" They're gonna say, "Oh yeah, that's a Disney story." It is not. These were actual people, and their stories belong to a specific culture, which Disney has pretty much grabbed. It has turned completely twisted, copyrighted it, and then put it up for the masses in a way that has completely rewritten this original story. And most people, if you go ahead and Google Pocahontas or Mulan, a lot of the results are going to be about Disney, and a lot of people just never knew and are probably never going to know they actually existed. And this is a form of cultural erasure. And as a musician, I also see this problem.
Yeah, but the problem is
Because
if you hold on, if you point this out to people, I've seen this a million times. If you point out these examples of absurd results of IP law, then everyone who's in favor of IP law, they will say something like, well, that's an abuse of the system, or that's going too far, or I'm not in favor of that. But they never have a principled opposition to the very fact of IP, which is the reason for this problem. I mean, you can point out a million examples and they will agree with you that every one of those is ridiculous. But they will say, but we still need protection for people's ideas. So they think you can
well,
have it
I
both
mean,
ways, but you can't have it both
it's
ways.
the same thing with everything, like they're gonna see the state and they're gonna see, oh, well, yeah, the state has obviously killed a lot of people throughout history, and maybe in just in the 20th century, it killed over 100 million people, both like the Nazis and the communists, and even the United States and Europeans with colonialism. And they're gonna look at that and see that the state is like literally a mafia which puts a gun to your head and forces you to pay them money just so that they can give you some sort of quasi public service that is absolutely terrible compared to any private alternative. And they're gonna go ahead and say, oh, well, yeah, but we can reform it.
I agree.
It
It's the
has
same.
never worked
It's
in.
this, but there's one difference. The difference is this: most people will admit that the mistake the problem with the state is that people have the mistaken idea that the state is necessary because without it you have chaos. So they're mistaken about that, but at least they understand that the state is dangerous and that they most people, even most minarchist libertarians, they regard the state as a necessary evil or as an unfortunate use of force that we have to accept, but they at least want to minimize it. They realize that when the state murders people, it's wrong. And so they try to limit this with constitutional rights and limits. But when you call intellectual property a property right, people think of it as a good thing and they see no principal reason to try to get. So most people would say if we could get rid of the state, it would be a good thing. It's just impossible to get rid of the state. We need the state,
Yeah.
unfortunately. But for intellectual property, they view it as a property right that's a good thing. So in a way, the false belief in the legitimacy and the necessity of intellectual property is a worst mistake because it's more insidious and it's harder to fight.
Well, in that terms, whenever people go ahead and say, well, we need intellectual property, without intellectual property, people are not going to be creating anything. So I usually go ahead and say, hey, well, if without intellectual property, people wouldn't have a reason to create anything, then we would probably not be having this conversation. We would still be banging rocks, living in a cave. Like, do a lot of people seem to like think that, oh yeah, everything we have now was created because of intellectual property. People had a reason to create things because they had a legal monopoly over their creations. I'm not going to say that a lot of things were created because there was an incentive, because you could monopolize it. But if we look at history, houses, this is something you mentioned in Against Intellectual Property all the way back in 2008, but it's a very good example. Um,
2001.
houses,
But go ahead. Yeah.
2001. All right, and then the version I read was from 2008. Anyway,
It was 2008, but that was based upon a 2001 article. But
all
go
right.
ahead.
Um, houses. The first person who came out of a cave and decided to build shelter by themselves, they didn't need any sort of patent law to do that. And what the thing is that people don't create necessarily because they're seeking profits. People a lot of time create because what they think that whatever they are creating is either gonna have a cultural or like a recreational value to them and to other people, or it's gonna have a practical value to them. And throughout history, many of the greatest inventions we can think of were made without the existence of patent law, or at least not the existence of patent law as we today know it. Because if we go back to in history, we know we already had like copyright and patent law all the way back into like the 17th century, mostly in the UK.
By the
Even
way, it's not just inventions in the past. It's also scientific discoveries.
right,
Even now, mathematical, abstract scientific discoveries, theories of physics, mathematical truths or ideas, those are not protected by patents, and yet we still have
thankfully.
lots of. I know, but the point is, in history, you had lots of discoveries and inventions and innovation without patents, and you had lots of scientific discovery and knowledge developed without copyright or patent as well.
Yeah, and but people seem to think that everything we have now is the creation of, like, it's the byproduct of the existence of copyright law and patent law. And they usually think that, for instance, many think that the Industrial Revolution was partly or in great part thanks to the invention of patent and copyright law all the way back in the late 18th century with stuff like um, I got reading this, but a lot of that was like from the UK, and that's not even the case. And I mean, if you go ahead and look at Venetia, they had the Venetian patent stated Venetian patent. What was it called? Venetian. Yeah, but the Venetian stated. Not really sure how it is pronounced, which was passed in the 15th century. And according to, for instance, Irandian, they would go, well, surely they would have passed that thing that protected the creations of people and gave them what basically was an early form of patents. And
Yeah.
Random would say, well, surely Venetia then became like a technological hub, like the beacon of progress in the 15th century. No, it didn't. 100 years later, Venetia was completely in decay. So there is no historical evidence. Like, I don't think there's any sort of actual proof to say that copyright and patent actually promotes
No, there's no
innovation.
proof.
If anything, it completely makes it impossible to innovate, because whenever you're gonna say, hey, I've got this great idea which I can modify this thing that I have here and make it even better, and once you do, hey, you cannot do that, that's our patent.
Well,
Where,
the idea of this kind of the early idea of intellectual property and of state granted monopolies is old. I found there's one reference to this cooking contest in ancient Sybaris, which is uh,
yeah,
2,500 years ago. And the guy who won this cooking competition would be awarded the right to be the only one who could make that meal for a year. So this idea has been around a long time, and it really exploded after John Locke's idea that the source of rights is your ownership of your labor and mixing it with something to be useful. That's kind of the essential mistake that has permeated all of modern political philosophy. Is this idea that creation of something of value or use, or that can be sold, is the source of property rights, which is the fundamental mistake um, behind modern justifications for intellectual property.
yeah. What you mentioned there, that story about cyber it is mentioned in the Deimos Sophistae, which is an ancient Greek text. I actually referenced that on my essay, and there are
Which what's the text?
Deimos Sophistae or Deimos Sophistae. I'm not really sure
Oh,
how it
okay.
is
I'll have to
pronounced.
look that up. I found it in another book, but hold on just a second. I need hold on. Okay, we're
All right.
back. I'll let you continue, but let's try to wrap up in about 15 minutes. So go ahead and get to
Yeah,
whatever you
there's just
any
really
other
just
questions you have.
three more things that I want to
Go
speak
ahead.
about, and I think we can speak about this really quick.
Mhm.
The first is, as I was telling you before about cultural erasure and all that. Well, I'm a musician. I've written a lot of music. I've recorded a lot of music. It's not a great deal of stuff. I mean, it's certainly not Pink Floyd or Dream Theater, but I've got my music, and I come from a smaller city, and much of our music culture here is do it yourself. So around here, I've got a lot of CDs from local bands.
Mm-hmm.
All of that stuff is not copyrighted. It's not the it has no phonographic copyright over the songs, and we've been working very much well in that sense. And I think music is one of those examples of copyright not necessarily being um a necessity. Like musicians are not making music because they want to copyright it. You're not going to a bar or to a restaurant to see a jazz band playing their own music because they decided to write it so they could register it and like sell it. And I guess it's the same thing with like writers and all that stuff. All creative recreational stuff. It's not written because somebody wants to profit of it, at least not in principle. They turn off the light. Wait a second. Okay, so one of the that what I was saying is that um people don't create things, like music or poetry or books because they want to profit out of it, at least not in principle.
Well,
And that's one of
it
the
depends. Maybe not monetary profit, but in the Austrian sense, it's for psychic profit. But
yeah,
that's
well, when I
yeah,
mean
yeah,
profit, it's
yeah,
not monetary.
right.
But copyright still exists in that sense. And when you actually look at it, then you get a problem, which is that copyright can actually lead to people not being able to create anymore, or to people not being able to actually share their works later. Because when you, well, maybe not you, but let's say a general example, when you record a song and you make it big, and you record an album, who ends up owning the phonographic rights and many times the copyright over that song? Is it you or the music label you signed to? It's usually the
Well,
music label.
it's changing a little bit, but usually, historically, it's been some publisher,
Mhm. Some
some.
publisher. Now,
Yeah.
what happens when you are somebody who has, let's say, political views that are not very much in the mainstream? Like in 2025, cancel culture is a thing, and a lot of people have been driven out of the mainstream because of their political views. Maybe we can argue all day long whether somebody should or not or shouldn't be driven out of the mainstream through like social boycott and whatever. I think that that's completely fine, and that's more of a thing that it doesn't it is not necessary to discuss because it's voluntary in that sense. But what happens when publishers own the copyright and the rights over somebody's work? You can have them end up pretty much censoring them.
Yeah, of course.
Um,
I mean, there was
you
I don't know if there's a new show called The Studio on, I think it's on Apple TV. It's about this guy that has a movie studio. There's one little plot. I think Seth Rogen's in it, and there's a plot where um, they buy the rights to a new movie from Martin Scorsese, but then it's about Jim's Jones and Jonestown, where they drink the Kool-Aid, right? But they're also making a movie about Kool-Aid, and they don't want to piss off Kool-Aid, who gave them the copyright to use Kool-Aid as their movie. So they bought the rights to this movie, and then they just killed it so that Martin Scorsese could not make a movie about Jonestown because it would hurt their relationship with Kool-Aid. So
yeah.
yeah, there's example that's fictitious, but things like that happen all the time where if someone owns the copyright to what you wrote, they don't have to publish it and they can stop you from publishing it.
I mean, yeah, that's a problem. And what I was saying is like, it hasn't happened yet. Not necessarily like complete censorship of any person, or not, at least not to my knowledge. But you get musicians like Ted Nugent or Morrissey, who you are well known to be like right wing, and in the modern day they are considered by many to be far right because, for instance, Ted Nugent is supportive of Donald Trump, and their music has been largely de-emphasized by their labels because they don't own it. So their labels are the ones who are capable of judging whether their music should be on Spotify, whether their music should be promoted. They don't own the copyright over their own music. And there is like this very funny thing that happened way back in like 2020, which I mentioned in my essay, which is that Herman Lee, the guitarist for a metal band called Dragon Force, he was streaming and played one of the songs by his own band and got DMCA strike. Like he
Yeah.
got DMCA striked for playing a song that he wrote.
Yeah. Well, of course, it's absurd. I mean, look, I'm publishing an article in a book right now by a publisher, and I wrote the article, and they wanted me to sign my copyright, but I refused to do it because if I sign the copyright, I can't even use my own article later. I can't republish it. I can't put it on my website. I can't make a new version of it. I can't translate it. But
It's a double-edged sword.
everyone else signs these things because they don't care and they don't understand. But
Yeah.
that is the implication of this system. That is true.
Yeah, it is sort of a double-edged sword. I mean, if you can benefit a lot from copyright as long as you can, as you are able to completely keep the rights to yourself if they are yours. But when they are not yours, you run into a problem, and it's one of these self-reinforcing issues that um, IP has, and it is that um, this is something that I call the PPP doctrine, patent, protect, perpetuate, PPP, which is that copyright and patent law it's a prisoner's dilemma. It exists, right?
Yeah.
So if it exists, if somebody can protect this stuff, then you're gonna want to protect your stuff, not because you necessarily believe in IP, but because if you don't, then somebody else probably will, and you're gonna have your access to your own creation void because somebody
Well,
else
that's okay.
patented
So
first.
that's a little bit
Yeah,
confused.
it's a
That's
bit.
more the case. That's more the case for patents than for copyright.
Yeah,
But yeah, go yeah. I mean, it's most people have this false belief that if you don't copyright your music or your book, well, first of all, it's automatically copyrighted. But they think that you have to have a copyright in your work because otherwise someone else will copyright it. But only the author of something can copyright it. So that's not
yeah.
really quite true. And the same thing with inventions. If I don't patent my invention, no one else can steal it because they're not the inventor. However, if they independently invent it and file a patent, then they could stop me from using my own invention. That is true.
Yeah, which is one of the things that I had mentioned earlier about parallel thought. I was,
Correct.
yeah, I was being perhaps a bit reductionist for clarity's sakes there.
Yeah.
But
Yeah.
well, moving on from that though, since it's better we wrap up. And the second to last thing I wanted to mention is that something that I also mentioned in my essay is that patent trolls and not only patent trolls, but the general issue with patents, which is that patents cost lives. Patents, like I think that unironically, patents, if they don't kill people, they prevent people from surviving, mostly pharmaceutical patents. Patents um, worsen educational quality, particularly in underdeveloped countries, like it is my case. And patents, this is something that might sound a bit like socialistic, but I think patents is a way that they can be used to reinforce the wealth of the more wealthier countries, which have historically, let's say, I don't want to use the word exploited, but which have historically had an interest in extracting resources from poorer countries. And I think that there is a
No,
huge
you're 100. No, this is not anti-capitalistic. It's not socialist. It's actually 100% true. America in particular, the West and America in particular, and in particular the pharmaceutical industry and Hollywood and the music industry are huge beneficiaries. They're recipients of wealth transfers from the rest of the world by means of patent and copyright. That is true.
Yeah. India, for instance, India has a long history of problems with biopiracy, which is that almost entirely American people would go and find some like the neem plant, for instance, in India and say, hey, this is cool. I'm gonna patent it. I'm gonna patent like a method of extracting oil from this tree, which has already
Yep,
existed for thousands of
absolutely.
years, but they went ahead
Absolutely.
and made a patent out of it. And then you suddenly have a whole population of millions of people who suddenly are infringing on the patent rights of that person who just came
Yes.
upon this idea or this method or this quasi creation of nature. And they patented it. Like
Yep.
how can many of these patents sure were later voided, thank God. But this happens. And another problem is that patent trolls, you got like these patent trolls who have historically patented rather menial inventions or random stuff, like in big numbers. And then suddenly when somebody has that idea independently and tries to apply it to their own invention, boom, they are met with a lawsuit.
Absolutely correct.
And that's something that I mentioned. I mentioned various cases. For instance, NTP Incorporated, which sued Research in Motion because of some wireless email synology. And then you got like Floatsys, which sued a lot of smaller app developers all the way back in like 2011, um, for because of like in application purchasing mechanisms, which is something that nowadays we got like in every single application on our phones. It's like incredible that this kind of stuff exists. And all right, Intellectual Ventures. Very sure you know that name, but it's like one of the greatest patent trolls in history. Like those
Yeah.
guys own a metric fuck ton of patents, and whenever somebody infringes on that, usually from parallel thought, or just because they are really good inventions that need to be used, they go ahead and file a lawsuit, or naturally they can force them to pay a fee to use their patent. And then you got like the pharmaceutical industry with its patents and its evergreening. And in the case of the US, you got the insulin market, which insulin in the US is stupidly expensive, and it is in great part because of evergreening. You know, like the patents on insulin are all the time renewed because they just make a small adjustment in the formulas of the insulin or in the way it is administered, and boom, you get like a 10-year extension on the patent of it. So that delays a lot the possibility for, how do you call it, not copies,
Generic, you mean generics?
biosimilars.
Generics?
Yes,
Generics?
generics and
Yeah.
biosimilars from entering the market. So then there is like this one case with the COVID vaccine, which back in like 2021, the UK was the UK government was blocking attempts to waive the intellectual property over some of the vaccines and treatments,
Yes.
while it is estimated that in average some 10,000 people were dying every day because they didn't have access to the vaccine, in great part because of that patents problem. And then again, this really has a huge effect on poorer populations, poorer
Of
countries, because
course. Of course.
If you live in, say, Bolivia or here in Argentina too, but maybe Argentina is a bit more developed than that. But if you live in a poor country, you cannot really have like a national company, a local company, which produces patented medicine, because patents apply globally thanks to like the
No,
WTO and
well,
the
that's not true.
WIPO.
No, patents are national, and usually what happens is when you get a patent, it's in one country, but usually you file similar patents in other countries, but it's too expensive to file it in every country. So what you do is you file it in enough countries where you can block the countries that produce it.
Mhm,
So for example, if a given drug is made in 5 countries, like the European Union and Canada and America or whatever, or Japan, China, you file patents in those countries, but then there's nowhere that they can't sell it to another country like Brazil or whatever, even if you don't have a patent there, because there's no one that makes it. But go ahead. That's
well,
roughly
thanks for
roughly
correcting
correct.
me on that, but I mean, even I think that even then, I mean, if you I were to open up like a company here that produces some drug that is patented in the US but not here, I'm pretty sure that eventually the patent holders would come around knocking and would file a patent for this country. And
Well, well, what they would do is if it's too late, they would suffer the loss there. But then the Brazil industry or the Argentinian industry could not. They wouldn't emerge in the first place because they wouldn't be able to sell their drugs in other countries, like in the big countries of the West. So it's unlikely that you would happen. And if Argentina started becoming a pharmaceutical hub, then that's another country that the big companies would file their patents in. So yeah,
mhm.
they would find a way to whack the mole and to stop it there. That's true.
So yeah, not only is pharmaceutical stuff the problem, but then also, as I was saying, education, and this relates more to copyright. And it is like, I'm not sure about you. You had your education, well, a long time ago, but now, myself, I went all my life to public school, public
Yeah.
university too. And copyright means that you cannot copy something that is copyrighted, and you cannot pirate a book that is copyrighted. But guess
Hmm.
what? We Argentines are not really, we don't have the level of wealth that Europeans or Americans have. So
Right.
we cannot go around affording expensive books, which
Correct.
costs, well, I'm not going to say they cost a massive amount, but which have a impactful cost for, especially for middle class people and lower middle class people.
Yeah.
So you don't go around buying those books. So what we did in school was the teacher would usually make us make photocopies of all these books, and we'd use those
Yeah.
photocopies
Of course.
to study. And even when we got to university, I was reading books about Python and networking and all, which were pirated online because the teachers told us, yeah, here's the link, pirate it, like the teachers. And you think that, I mean, in the US, this would probably, if this was done like at Harvard, then that would probably end up in a lot of
Yeah,
legal
no. What happens
repercussions.
is the publishers, they turn a blind eye to massive copyright in the third world because they go after the low-hanging fruit. And another thing that sometimes happens is you'll have a publisher like say Wiley. There's a famous case. So you'll have these publishers and they will publish a cheap version on cheap paper, like let's say they sell a textbook for $200 in the US. They might sell it in India for $15 or $30. But then what happens is you have arbitrage happen. So you have someone, they go to India or Argentina or whatever, and they buy those copies and they bring them back to the US and try to sell them there. And of course, there was a big lawsuit. Wiley, it's a famous lawsuit. Wiley tried to sue and say that if you import a copyrighted work, it's still copyright infringement under this thing called the exhaustion doctrine. And then there was a big legal case where the court, I think the court said, I think they sided with against the publisher. I could be wrong, but it was a big legal battle first. But that's just an example of how they will do everything they can to maximize their profit, and it will hurt people.
it does hurt people, and well, it's the same with research papers. Like a lot of research papers are naturally copyrighted, and you need to pay a lot of money to access that, which also means that people in poorer nations have like a completely limited access to a lot of knowledge and a lot of tools to aid their own progress, which is incredible when you think about it. And maybe we are not yet there, but we are quickly moving into a world where surveillance, and especially the way that copyright is um,
Well, this may be
inf-
before your time, but this guy, the young guy, Aaron Swartz, who was the co-inventor of RSS and podcast, some technology. He was a student and he took a laptop and used I think Columbia, one of the university's servers, and he uploaded thousands of these research papers to the internet, which was a copyright violation, and he got charged with criminal copyright violation. This is just a 23-year-old guy, and he was threatened with like dozens of years, maybe life in federal prison. So he committed suicide. He killed himself because he was going to be basically killed because of copyright.
um,
That's just
this
one
is
example of
that's
many.
that's one example. This The creator of FM radio technology, Edwin Howard Hamstrom, he had created FM radio technology.
Yeah,
The AM industry opposed him. RCA copied his patent without
yeah,
any license.
yeah,
He had to go to really extensive legal battles over that, which
yeah,
completely ruined his psyche. He ended up like having breakdowns and paranoia. His wife tried to commit suicide, I believe, and he ended up committing suicide himself because of all this stuff,
yeah.
which is completely like it's mind blowing. So just to um, be done with this, like the last thing we can talk about, and probably we're gonna get over with rather quickly, is like the last part of my essay deals with not abolition but with reform. And this is not because I am against abolition. I mean, if it was up to me, I'd completely get rid of copyright and patent and trademarks and everything tomorrow. But it's not realistically viable, not yet. So I dedicated this part with what I consider to be a more realistic solution to what's an absurd problem, which is, well, IP. And just to go over it a little bit, my um, my main
You might need to
proposal.
speak up a little bit. You're getting quiet.
Yeah, my sore is kind of my throat is kind of sore now. But my main proposal is to replace exclusivity, IP exclusivity, with what's basically I would call it a royalty system with decaying exclusivity. So the idea is this: instead of copyright and patent law saying, "Hey, you cannot use this," copyright and patent law should grant people shorter terms, and these should make it so when the patent comes into effect or the copyright comes into effect, um, they would have a right over 100% of the profits or the income of any work or any creation or the just the general usage and marketing of their own creation. And this would be decaying over time. This rate would be decaying over time until it reaches zero, which is when basically the patent would expire. So let's say that I make a new thing, like let's say it's a new storage device. I patent it, and so say the patent lasts 5 years. So for you divide those 5 years by you divide yeah those 5 years by 100 or so, and you got that declining every certain amount of time. The amount of royalties you can claim over what other people over the use of other people over other people's use of your creation, it's gonna be that number, right? So it first is 100%, then a certain amount of time passes and it's 99, then 98, then 97, then 96. So what happens here is that other people can use your creation. They can market it. They can do whatever they want with it, but they have a legal obligation to pay you. They
Yeah,
have to pay you a
yeah.
percentage.
I recently had a podcast about this a couple days ago. It's there's lots of proposals to reduce the cost of IP law, and one of them would be for patents. You would get rid of the well, you could change the term. You could also get rid of the injunction. In other words, all you can do is demand a payment. That would definitely reduce the harm of IP law. I don't know why it's practical because everyone that supports IP would oppose that, just like they oppose it now.
Well,
But
I mean,
sure,
if you think
that's a
about it, it's actually perhaps a much more utilitarian um, system, because a lot of people defend IP on utilitarian grounds. But if you think about it, if you allow people to use patented stuff while also paying the creator a fee, and also giving a not exclusivity but advantage to the creator by giving them the capacity to create to produce their patent and to produce their creation at a rate that's way below that of their competitors, because their competitors would have to pay royalties, then you can have a market that's not monopolized. And while sure, you would have like this one company, this one organization or one individual who would offer the same product at the cheapest price, you could still have people be willing to pay more for an alternative that might be of a better quality or have something in a specific that they like, which is, if you think about it, it's the best thing you can possibly have, which is much better than just exclusivity and
no, it's
monopolizing
not.
any creation.
It's not. The patent people, they believe it's a property right. Okay, so
Mhm.
they look at it like you have an office building, and right now you can physically prevent someone from using it without your permission, and then you can use that right to exclude them, to say, if you want to use my building, you have to pay me whatever we negotiate. But if you
Mhm.
take away that right to stop them, that reduces part of your bargaining power. This is exactly why the IP and the patent proponents in America go crazy when the Supreme Court law makes it harder to get an injunction. Um, you're right that that would make it better because it would reduce the harm, but it would reduce the harm by reducing the strength of the patent right. And everyone's going to oppose that, just like they oppose getting rid of patents or reducing the term. So all you're
Yeah.
doing is you're coming up with ways that you could reduce the harm of patents or IP, and you're saying it doesn't hurt that much. It still gets you some of what you want. That is true, but they're still going to want everything they can get. The IP
Well,
people.
because I don't think they really defend IP because on utilitarian grounds or ethical grounds, but they defend IP because they have just a preconception that is deeply ingrained into them. And it's the same people. I guess it's the same reason why a lot of people still defend Marxism when it's been proven that, well, it doesn't work in practice. It's a complete mess, and you got all of history to prove that, but a lot of people still offend that. So in that sense, I guess this is not really something that you would talk about to someone who is completely in line and happy with the current state of IP. But this is something that you would have to bring up to somebody who is in the middle or who is not very well informed on that. Yeah, like you explain to them the problems with IP, and you say, hey, well, we don't have to abolish it, because a lot of people are gonna hear, well, abolition, that's crazy. What is wrong with you? But if you tell them, well, we can reform it, then you can um, convince them to support that idea.
Yeah.
And I think
No,
that
you
if
can't. No, you
you
can't. No, you can't. No, you can't. I've tried,
are you,
but I know what
you
you can't.
I well, I'm gonna try myself, and
Go ahead.
maybe I'm gonna tell you someday. Um, But I think that if we are capable of convincing people that to reform IP in a way that reduces its harm and reduces its grip on the market of ideas, we could have abolitionism um, become more mainstream in the future. It's my
Okay,
personal opinion. Like if you
go for
change
it. Go for
if
it.
you yeah, I mean, I think that we need to shift the Overton window
Well,
on this topic.
technology, but the thing is, technology and reality is shifting the Overton window because most people, like say in third world countries, like you say, they copy and they pirate, and even in the West, students and regular people, they pirate all the time. But
Yeah,
companies can't do it. Companies can't do it. So that's the problem is the big companies still have to obey the law because they could be easily sued. But yeah, your average person doesn't think there's anything wrong um, with piracy on a small scale, and they do it all the time. Even people that are pro copyright, I guarantee all these IP people, these Randians and these minarchists, the utilitarians, when they're doing their research and they're browsing things on the internet, um, they sometimes go get a pirated copy of a book because it's easier and there's no other way. They do it all the time. So technology is slowly reducing I mean, you remember these commercials in America anyway, the RIAA put out where they say you wouldn't you wouldn't download a car, so why would you download a song?
yeah,
And people are like,
yeah,
I would download a car. If I could download a car,
yeah.
I would
I mean, you
download a
can
car.
3D print a car now. I mean, you
Exactly.
can
That's
3D print a car. Are you when you 3D print it, maybe you are you are infringing on copyright, but hey, you can pirate a literal car in
I know.
2025, and a lot of people have this idea, like one of the things that I hate is that a lot of people think that, oh well, people will keep pirating. I mean, people pirate because they like to pirate. People pirate because they don't like to pay. And maybe that's true, but if people were to pirate because they don't want to pay, just because they don't want to pay, then I mean, what I try to get to here is that hey, copyright is not is stopping people from pirating.
No, it's not stopping them.
It's not stopping people from pirating. And this is something that appears on your website, and it is that um, we are not supposed to support a failed business model. And what is a failed business model? The one that relies too much on copyright and that it relies too much on the state enforcing its existence. Are you familiar with a platform like Steam?
Yeah, the
Well,
video game
Steam,
thing. Yeah.
yeah, Steam. What does Steam do? Um, Steam sells video games, a lot of video games, thousands of video games, and it also sells the soundtracks for video games, and it even sells movies and some hardware and software and all. And Steam is widely used. Like people use Steam. I think there is well over 1 billion users by now. Why do people buy games on Steam when they can just go ahead and torrent them? I mean,
It's more convenient.
it is more convenient. And some people will say, hey, well, a Steam exists because copyright exists. If copyright didn't exist, then people wouldn't buy games on Steam because Steam wouldn't have a reason to sell them. Well, they would.
No,
People
they would do
buy
it.
games.
It might be cheaper, but no, you would
Yeah,
still have
but
the service like Steam.
people buy games from Steam because, first of all, it's much safer than going into these Russian websites where anything you click is probably going to download a Trojan to your computer. They get automatic updates on their games. They have a whole integrated ecosystem of trading cards and digital inventory items, which are kind of like NFTs, and in internal marketing Steam, like you literally have an internal marketing in Steam. People buy and sell things based on offer and demand, which is something incredible. People buy games from Steam because it is convenient and it is a good and
Yeah,
Steam is a
you're
good
right.
business model because it is convenient. It provides people with something that they always wanted. Like somebody in who was buying and playing games in 2000 had to go ahead and go to a GameStop or some other place, find a game and judge that game by the cover art go home, put on a CD, install it, put on the CD to play the game. They wouldn't get updates. It was like not convenient at all. It was a pain in the butt for anybody who liked to play games. And now 2025, you can just go ahead, turn on your computer, go to Steam, find any game you want. You can look at hundreds of pictures and videos and gameplays and streams about it and read people's reviews, and you just click 3 buttons. You bought it, you can download it, and you can play it. And if there's an update, you're gonna get it automatically. You can unlock achievements, which actually achievements are not meaningful at all really, but they just feel good to unlock. It just feels good to have like that notification appear on your screen that says, "Oh, you killed 100 enemies. Congratulations, you got this achievement." And that's just a good business model. And it doesn't need copyright to exist. It doesn't. And it's the same with platforms like Netflix or Spotify. Like streaming services and all these things are just a living proof that copyright is not necessary to stop piracy. It is a proof that piracy is stopped by making things more convenient, by making
I
people
agree.
prefer to pay instead of having to pirate. And
I
even I
agree. Well,
myself have engaged in buying stuff even when I can pirate it.
of course, lots of people do. By the way, we need to wrap it up, but let me
Yeah,
mention, I think you should go do what you want to do. Try to do everything you can. If you come up with good ways to persuade people, especially in Argentina, that's good. If you can persuade Millet to do more, that would be good. By the way, the title of your paper is almost the same as one of my papers, which is called
really?
Ideas Are Free. You can use it. I don't care. But my paper is called Ideas Are Free: The Case Against Intellectual Property Law. It's
Oh
almost the
my
same as
God,
your
yeah.
title.
Well, it's something I mentioned in the end. It's that these ideas, like everything I wrote, is not my idea, but it's the ideas of like all the people who have
Of
shared
course.
the
Me too.
same way of
Me too.
thinking.
That's how ideas work. Yeah. But
So I
I've got to wrap it up.
tell
But
people that,
I enjoyed
right,
talking to you. I want you to good luck with everything. Feel free to contact me
right.
again. But
One thing that I just want to recommend you a book if you have time to read it later. It's The Way of Chuang Tzu by Thomas Merton. It's a book on Taoist philosophy, but even if it's like thousands of years old, trust me, it has a lot of libertarian values in there, like proto-libertarian values. I'm pretty sure you're gonna like it.
Merton, Merton.
Yeah,
All right, I'll look it up. There's
The
a
Way
book
of Chuang Tzu.
there's a book, the book I'll put on my show notes. It's called it's called uh it's something about an ancient Chinese saying, to steal a book is an elegant offense. And it shows that in some cultures they don't regard copying ideas as an insult or as a harm. It's sort of a compliment, you know.
Yeah.
Yeah.
Well, for thank you very much for this. I never expected to have a conversation with you, so this was very much enlightening.
All right. Well, good luck with everything, and
Well,
we'll stay in touch.
have a nice weekend. See you.
Take care. Bye bye.